Good morning. This is Judge Alyssa Perez.
Good morning.
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 Good morning.
Stand by. We just lost her.
Good morning, Judge. Can you hear me?
Just a minute. Who's give me 1 second. Who's that on the cell phone ending in 001, the one that was just speaking? Can I get your name?
This is Israel. Excuse me. This is Israel Guardiola. I'm representing Jose Leon Soto.
Okay, give me a second, Mr. Guardiola. We'll get to you in just a minute.
Sorry about that. Zoom does not want to play nice this morning. We'll try again. This is Judge Alyssa Perez presiding over the 210th District Court civil docket for February 16, 2022. All matters being heard today are being heard in accordance with all emergency orders and directives regarding COVID-19. In addition to that, we are streaming all matters live via YouTube. Mr. Pantoja, will you call our first case?
Yes, Judge. Cause number 2020 DCB 3028, Francis Properties Limited versus Loop 10 LLC. Announcement of council, please.
Harold Davis on behalf of the plaintiff, Your Honor.
Sam Sipes on behalf of the defendant, Your Honor.
Good morning, gentlemen. Let's see, what are we actually scheduled for? We are scheduled for the motion for leave and a final status conference, but let me actually access Odyssey because I feel like there was more than that. Okay, sorry. So slow.
Your Honor, in addition to the status conference and my motion for leave to file a summary judgment motion about 6 days late, Mr. Sipes has filed a response to that and a motion to continue. He didn't set the motion to continue for hearing, but I have no objection to it being heard today too, because it makes sense to have it part of the other matters that are before the court.
And so Mr. Sipes, forgive me because I think I received an email with those documents, but offhand right now, the motion for continuance is regarding the jury trial and the actual schedule, or is it reference something more specific?
Your Honor, first off, I would acknowledge that Mr. Davis is correct. I filed my motion based upon an amended pleading that he filed in January. And the amended pleadings stuck in a claim for exemplary damages. He also added some factual allegations that on the surface of them, in my mind, did not indicate a justification for exemplary damages, but that may be the sole issue that's between us. But what bothers me is his list of potential witnesses was very short. I only took a deposition of one of his people, and that was certainly did not cover anything about exemplary damages. Excuse me, Judge. And so basically, I filed the motion saying that I need to have some more, at least to bring those witnesses in and ask them what they're talking about in terms of exemplary damages and why. And he uses that our actions were taken with malice. So the bottom line issue is I'm very concerned that if I use the word malice in talking to one of my witnesses, that I'm going to open up to all kinds of witnesses that have not been named, that he has potentially prepared to come in on this exemplary damages, and I'll be totally unprepared for. So the bottom line is I thought I needed some additional discovery there because of adding that exemplary damages, which I consider very dangerous. Notwithstanding it, I agree with him. It's not an additional cause of action, but I can't ignore it. And if we open up on the additional damages, I said, I think the court ought to consider a continuance. I don't know how the court's docket is. We're set for April 1 for a jury trial. I can go then, and maybe it's better a subject for motion in limine, but it evidences a real concern on my part as to where we are in discovery. I feel like we have not completed discovery, and I have not. And I think it is because of a January filing, which is after the discovery deadline date. And so at the very least, I think I'll have the opportunity to seek some discovery, or maybe through discussion only initially with Mr. Davis. But seems like we're down to filing paperwork to get things done now. So that's what I got to say, Judge.
Understood. And so I do have now the motion for continuance in front of me. Look, gentlemen, realistically, before we really delve into all of the things that we could potentially argue about today, or you all could, realistically, that April 1st trial setting is
Not going to go.
not happening.
Yeah, that was my first, that was gonna be my first question. I just got a notice from the 448 saying all the March trials have been canceled. And
Well, we're not going that far, but we are because of a few different things. We do not have, first of all, panels for that date. Okay, so I would already have to be looking to move you all to a different date. I could get one close to it, but it doesn't sound like what is happening right now. It sounds like, first of all, we have a defense motion for continuance, and quite frankly, I'm going to grant that. And it sounds to me like that may resolve some issues, or at least give us a bigger window within which we can possibly work these out, or do what we need to do to get to a clearer place in this case.
What I would request in, Judge, if you go ahead and grant my motion for leave and then not set the summary judgment until 21 days after today, then that way he's gotten the full benefit of the time that we were talking about, and we don't have the problem with the trial deadline anyway. So I'm good with you granting the continuance, granting my motion, and we'll get a new trial date and kind of go from there.
Mr. Sipes, what is your opinion?
I'm in agreement with that. I really only filed an answer to his motion to allow him to late file, because he filed a motion for sanction against me, and the motion for sanctions on the discovery was filed 7 days after the discovery was due. And coincidentally, his motion to allow him to late file his summary judgment motion was 7 days. And so it didn't make me mad, but it irked me a little bit. I felt like a telephone call would have worked better than a motion for sanctions. And that discovery has been done. It was done 8 days. No, it was 7 days late. We got it filed. It was 7 days late. So that's that. I'm doing a little bitching there, but that's all. You know.
Oh, okay.
And at his age, I shouldn't be irking Mr. Sipes.
So what I originally had thought was to not restart the case, but give you a new trial date, probably towards the end of the year. We could even go into 2023 if you think that's necessary. And basically get a new scheduling order going. If you would prefer to do it the route that Mr. Davis says, then maybe I would hold off in setting the trial date and go with those initial settings.
No,
but I just assume get you on a new track.
No, that's what I was saying, Judge, is grant his continuance, grant my motion for leave to file late. We'll set the summary judgment 30 days out or whatever, so that he has plenty of time and hasn't been harmed. Give us a new trial date. I'll do a new scheduling order, and we'll go from there.
Mr. Sipes?
I think that sounds great, Judge.
Okay,
and Mr. Davis, thank you.
Good. Let's go ahead and do that. So the motion for leave is granted, although with the new scheduling order. I don't know if that's really necessary, but we will get the scheduling order to you, Mr. Davis. And then you said you want the summary judgment 30 days out?
Yeah, at least 30 days out so that he has time.
Let's go to, let's do April 13th, Sandy. We'll do that in the morning. So we'll do it at 11 a.m.
Yes, ma'am.
And then if we could just get the new scheduling order going. Let me ask for the trial date. I can probably put you in sometime in November. Or is that
works perfect, Your Honor.
That works well? Okay, great.
Yeah, my last trial setting is October 3rd for this year, and then I already got 2 in 2023. So
let's do docket call November 2nd Trial date, November 4th. Okay,
And it's
What's the trial date?
November
Was that-
4th is the trial date. And I'm
The
sorry,
4th?
Mr. Sipes? Yes, sir, the 4th.
Your Honor, on April the 13th, I've got a hearing scheduled at 9 o'clock in the morning. I don't know how long that's going to take. And that's the only day in April I've got a conflict.
Let's do April 6th then.
April 6th. All right. And that's 11 o'clock.
Correct.
Thank you, Your Honor.
Thank you,
Judge.
gentlemen. We'll get you the new scheduling order, okay?
You got it. You take care, Judge.
Take care.
Bye.
All right, Chewy, who's next?
Judge, bottom of page 1,
Mhm.
cause number 2020 DCV 4223, Leticia Isabel Lawrence et al. Versus Tenet Hospitals Limited et al. Announcement of council, please.
Olga Heller for the plaintiff, Your Honor. Good morning.
Morning.
Cynthia Llamas for the Hospitals of Providence Northeast Campus. Good morning, Your Honor.
Good morning.
Judge, I'm Frank Doyle. I'm here on behalf of Kristen McTighe and Pearsall Emergency Medicine.
Heard of the other hearing, what is happening with that jury trial date. So we're here for a final status conference. How about we get an update and we'll go from there.
So,
Anyone?
Judge, we've got a couple of depositions to finish up. Well, actually more than a couple, probably. We've got the defendant, Miss McTighe, a nurse from the hospital. We've got 2 of the plaintiff beneficiaries to depose, actually 3 of them to depose, and all expert witnesses still need to be deposed.
Okay. So what's anybody have a problem with not seeing a trial here in the next 2 or 3 months? We have April 1st, but as I mentioned in the other hearing, I don't have panels. If you all are in agreement and we need to move this, have you all thought of a timetable?
Have we all thought of what, Your Honor? I couldn't understand. I don't oppose moving the trial setting. We're not ready.
Okay. So I timetable, do you want something like November? Do you want 2023?
I think 2023 is more likely to go, early 2023, but I have not spoken with any of my other parties' counsel.
I'm
Judge-
fine with that, Your Honor.
Go ahead, Mr. Grajeda.
I'm fine with that, Your Honor. Excuse me, Mr. Doyle.
I'm sorry, Paul, I didn't mean to step on your toes. That's also fine with us, Judge.
So let's look at January 27th, 2023 with a January 25th docket call. Yeah, I guess we'll do a new scheduling order as well, Sandy. So if we'll get that out to everyone, just, oh, yeah, gets a little frustrating with all the, we think we're going and then we're not going, and I hope it ends soon. But thank you all for your understanding. I guess it works for you all in this one. Let us know if you need hearings on anything, and if you will return the scheduling order, we should be good to go.
Okay,
Thank you, Judge.
Thank you, Your Honor.
Y'all have a
Stay
good day.
safe.
You too.
You too.
Yes, ma'am.
Bye.
Thank you.
Thank you.
All right, go ahead.
Okay, Judge, top of page 2, I'm just making sure that all parties are present.
I think I see them.
Okay, it's cause number 2020 DCV 2256, Christopher Hines versus Jesus Mesa et al. Announcement of council, please.
Good morning, Your Honor. Rachel Hatton and Kelly Gibbons for plaintiff.
Good morning, Your Honor. Dave Larson here for defendants.
Okay, let me just go back. This is one of a few cases I was looking at for today. All right. We have motion hearing, and final status conference. We're already all the way in November. That's good. All righty, Mr. Larson.
Yes, Your Honor. Are we going to go with the motion for sanctions first?
Yes,
Okay,
sir.
sure. All right. Your Honor, we've been before you a couple times, but I'll just give you a quick reminder of what this case is about. Essentially, it's a low impact minor motor vehicle incident that happened at a truck stop. Happened in April 2019. Plaintiff in his petition, his responses to written discovery and 2 separate demand letters claimed that the injuries that he suffered were the result of falling out of his sleeper berth. He was also in a commercial motor vehicle, semi. Fell out of his sleeper berth and struck the ground, and that was the mechanism of injury for his injuries. Now, plaintiff throughout the case has perpetuated this statement about how he had a mechanism of injury. And the point of it was to basically prop up a case that had no value because there was no mechanism of injury. That's something we learned for the first time in his deposition. Now, let me go into a little bit more detail on specifically where these misstatements come from and why it's significant. So his medical records and the settlement demands that he sent, again, they claimed that he was knocked to the floor, and that was the mechanism of injury. Now, plaintiff relied and cited those medical records in all versions of his disclosures and all discovery responses, which were submitted under oath when asked about how the incident occurred, referred back to that. Now, as I mentioned, on in his deposition, which happened on October 29, 2021, more than a year after this litigation started, plaintiff for the first time revealed that there was no such fall to the floor, and there was no mechanism of injury whatsoever. He admits this. He said that his memory was blurry, which is something that plaintiff focused on in his response. But what he does remember is that he sat up, put his 2 feet down, and did not jump out or fall out of bed. And it's clear in his testimony, Your Honor. I mean, plaintiff tries to make a big deal out of the fact that he was asked multiple times. And the reality is occasionally that happens in deposition when you don't get a clear answer. So he testified that his memory was blurry, but he did remember those aspects. And that's the crucial aspect that we're talking about here, which is what actually happened and whether there was a mechanism of injury. Basically, what plaintiff is trying to do is explain it away after the fact in the response, and it's pretty transparent what's happening with that. TRCP 215.3 permits a trial court to sanction a party for abuse of the discovery process, including striking out pleadings, dismissal with or without prejudice, rendering judgment against the disobedient party. And the standard there has to be a direct relationship between the improper conduct and the sanctions imposed. Another thing to note, Your Honor, I think you were looking at where we are trial-wise and how it's already been continued. We were before the court right around the time of plaintiff's deposition, within a couple of days, and because we were set for trial in December. And so what we have here was plaintiff. I understand trial eventually got moved regardless, but if you look at that point in time, plaintiff is testifying less than 2 months before trial and revealing this for the first time, after we've litigated for that long. Plaintiff, essentially, what was being concealed was that these are meritless claims. And so by dismissing the case, these, the sanctions that we're requesting, would be treating the claims for what they are, which is meritless. Issuing the sanctions would not be excessive or unjust, the second element under our TRCP 215.3. In this case, Your Honor, the punishment fits the crime. Flagrant bad faith, callous disregard for the rules is demonstrated by the repeated misrepresentation and failure to ever correct this misrepresentation throughout the litigation of the case. Even in plaintiff's second settlement demand, which was actually after plaintiff's deposition was taken, they continued to perpetuate that lie about how he was injured. There's no correction of it. There was never supplemental, responses that corrected the issue. Not that it would have fixed it, but it demonstrates the attitude of plaintiff as it relates to the discovery abuse. So on that basis, Your Honor, we'd ask that the motion be granted.
Thank you, Mr. Larson. Ms. Hatton.
Yes, Your Honor. I think the only thing that's pretty clear here is it seems to be a retaliatory motion for sanctions. If Your Honor would remember, we had originally moved for sanctions after over a year into litigation and after the statute had run, and after certain representations had been made to us about who the driver was, defense sought to withdraw deemed admissions and disclose a potential new party, a new driver. We moved for sanctions, asked for continuance on those sanctions, wanting to actually find out who this driver was. This seems to be retaliatory. But let's go to the merits of defense argument. This plaintiff has made certainly no flagrant misrepresentation. Plaintiff nor I have lied to the court. Let's put this in context. Defense alleges that plaintiff has misstated our mechanism of injury throughout multiple instances in the case, the claim, discovery process. That's untrue. Specifically in the facts of our petition, which is what one of the exhibits defense cites to as a misrepresentation as to the mechanism of injury. And I'll read, Your Honor. The only thing it says is plaintiff Christopher Hines was sleeping in the cab of his tractor trailer while parked in a parking spot at Pilot Truck Stop. Defendant at that time we believed was Jesus Meza, was operating his 18-wheeler in the parking lot. Defendant Jesus Meza then turned left, colliding hard into the front of plaintiff's parked vehicle. As a result of the collision, plaintiff was injured and continues to suffer injuries and damages from this incident. So there was no representation as to any mechanism of injury there. That's the first time defense is wrong in their motion. As to then the next thing defense points to is our responses to discovery, to the sworn interrogatories. That was interrogatory number 8, and plaintiff very clearly said, and included even in defense motion, we do point to our initial disclosures, which points to our petition. So that's what our petition and disclosures has, that plaintiff was sleeping and was hit and was injured. But further on in that answer, plaintiff Hines says, I was sleeping in the cab of my truck. I felt a big bump where the rocking of my truck woke me up. When I awoke, I saw nothing but white in my window, which was the defendant's truck. I had to weigh the defendant driver down. There was another guy driving for the same company directly behind the defendant driver. I feel he took the turn too short, trying to go around my truck. The collision took the front grille off of my truck. Again, no statement or misstatement about a mechanism of injury. So that's the second time defense is wrong and has actually misstated what the contingents are in our pleadings and our discovery responses. The plaintiff sat for his deposition, which was noticed by defense so close to trial in October of last year. And that was the time after the repeated instances of saying that it was all blurry. He states what defense has now conjectured and concocted to be this grand scheme, and it's just simply not. In our demands, so that would be the other thing, the demand letters. One was sent before suit was even filed, and one was sent shortly after the deposition. Myself as plaintiff's counsel, we relied on the medical records that was taken at the emergency room, so very close in time to the incident, where he states that he fell off the bed, or the bed of his cab. Then over 2.5 years later, he testifies, stating multiple times that it was all blurry, and defense wants to use that as their sole basis, their conclusory notion that it's all a big scheme and lies. Your Honor, that it's unjust. This motion for sanctions should be denied. Defense has certainly not met their burden to show that these sanctions were warranted and merited.
Mr. Larson, do you have anything else?
Yeah, Your Honor, I apologize for the statement about the petition. That was in the motion. Looking back now, Ms. Haddon's right. It's not in the petition, but it is in every other place that I mentioned. So for example, on the request for I'm trying to remember if this was the required disclosures or in response to requests for disclosure, because the rules change around that period of time. But the factual bases of plaintiff's claims are found in the following documents. This is in their initial disclosures under Rule 194, and expressly incorporates and attaches the documents that I'm referring to as far as the medical records. So it's certainly been perpetuated under oath multiple times. And throughout the litigation of the case, I agree on the petition. It's not stated in there, but it's stated in every other place we mentioned.
Okay.
Briefly, Your Honor.
Yes, ma'am.
The medical records weren't even written by the plaintiff. They're written by his doctors. So if that's the sole basis of our big lie, it wasn't even written or drafted by the plaintiff himself.
Okay. Is that everything?
I think that's it on this one, Your Honor.
Okay. Okay, so the motion for sanctions is denied. What else, Mr. Larson?
That's it on our motion, Your Honor. And I believe plaintiff has a motion.
Ms. Hatton?
Yes, Your Honor. We are still trying to get the deposition of the corporate representative of Freightline. Freightline is who we believe, who all signs have pointed to, was the employer, certainly had the DOT number that the John Doe, at this point still defendant, was operating under. Included in our notice was a list of topics, and defense has objected to it. So we are moving for the court to overrule the objections and compel the corporate representative so we can figure out who was driving this truck and what happened. Specifically, Your Honor, defense has objected to our use of John Doe. Well, we've used John Doe, and if it would be helpful, Your Honor, see, I pulled out, I can share my screen if you don't have it in front. I'm unable to share my screen. I was going to highlight what those definitions were. But the definition, the term John Doe shall refer to the driver of the tractor and trailer VIN number. We list the full VIN of both the tractor and trailer on April 24th, 2019, and or the driver involved in the collision on April 24th, 2019 with Christopher Hines in the parking lot of Pilot Truck Stop right outside Abilene, Texas, within the city limits of Taylor County, Texas. Defense objects that it's unknown and therefore vague. Your Honor, we certainly don't know. The corporate representative should be in the best position to know, and that should be overruled. It is necessary, and our definition does point with enough specificity that they know who we're talking about or should know. If they do not know, or the representative doesn't, then he or she is free to testify to that under oath. Similarly, the use of the word the wreck in our noticed topics was also objected to. Again, the wreck is the same wreck that forms the basis of this lawsuit. It's defined. The term the wreck is the collision on April 24th, 2019, from which this lawsuit arose. Again, it is clear enough what we are needing to depose the corporate rep and should be overruled so we can figure out what's going on. Lastly, there's two objections to our topics 41, 44. Those are, we are seeking topics about the Freightline's prior employers, prior employment, prior DOT number, DOT involvement. It goes to our gross negligence claims and is discoverable. It certainly is reasonably calculated to lead to admissible evidence on that. Rather than beat the dead horse, I can let Mr. Larson speak now, and I'm certainly happy to clarify our need for these topics further if the court would require.
Okay, Mr. Larson, go ahead.
Yeah, it's a very simple motion, Your Honor, and the objections are very simple too. They want a corporate rep or deposition about a person that's unknown and does not exist. So it's a John Doe. Your Honor, I see you shaking your head, and I'll explain why.
Well, let me tell you why I'm shaking my head, because I feel like we've been on this question for the longest time.
Your Honor, I can gladly explain. I gladly explain. So I finally got in touch with someone that they've named, who's Hugo Hernandez, and it's my understanding that he was the driver. Plaintiff was working on getting him served with the petition and to take his deposition. I proposed to plaintiff when this motion was filed before it was previously set for hearing that we push it back and amend the topics. Maybe not even push back the deposition, but amend the topics to refer to that person. It would make sense to take his deposition. If he acknowledges he's that person, then we could amend the topics to be not John Doe, who isn't a real person, and refer to Hugo Hernandez if that is what the result of his testimony is, which I believe will be the case. And then we'll gladly provide deposition testimony from the corporate rep on the hiring of John Doe. But Your Honor, I mean, to require I understand the court doesn't agree with the fact the company didn't have knowledge of this incident, but that is the fact. So, I mean, the standard itself is that one, the party seeking a deposition as this has to state with reasonable particularity the matters upon which examination is requested. It's then on the corporation to produce a witness to address those topics, but only on matters that are known or reasonably available to the organization. If they don't know, for example, we're talking about John Doe. I mean, so I don't understand how the corporation at this time could provide testimony on the hiring and training and background and criminal history of a person that's by definition fictional. We are, Your Honor, that's the definition of a John Doe. So I'm happy to provide this. I think the motion's premature, and to grant it would require us to provide testimony on the background of a person that does not exist by definition. So, I mean, 44 of the topic areas, Your Honor, relate to John Doe. So I'm sorry, 44 topics, 25 of which incorporate the John Doe definition. The rest of the issues relate to knowledge of the wreck and plaintiff's injuries. Apparently they want a corporate rep to testify as to what plaintiff's injuries are. You know, essentially that's the basis of it. Again, you know, they were already able to serve Hugo Hernandez with a subpoena, and I've asked them to serve him with the petition. At that point, we would be able to enter into the case on his behalf and provide him for deposition as well as the corporate rep. So there's no issue as to we're not going to provide corporate testimony on the vast majority of these topics. It's just, it needs to be on a concrete individual in order to answer these questions. You can't answer John Doe's logs relevant to the wreck. If we don't know who that individual is, we can't provide testimony on it.
Okay. Ms. Haddon, anything else?
No, Your Honor, I think it's pretty clear what we're needing to find out. I would love if defense would accept service of Hugo Hernandez and answer for him in this lawsuit. We could simplify at least that matter, but as it pertains to the corporate representative deposition notice, the terms are clear enough and their objection should be overruled.
Okay, defendant's objections are overruled and the motion to compel is granted. He is going to be ordered to be deposed within 60 days, whoever that corporate rep is. I think that's, considering our timetable, plenty of time to work things out. It looks like we have a final status conference on April 6th. Sandy, we're going to cancel that final status conference just to bump it back a little bit, because I think that will put us right before any deadline to have that deposition occur. We'll go to May 11th. If there is anything that requires a hearing in the interim, I know you all will let us know and we will get you scheduled. Because between that May setting, then we don't have anything else until September. And I feel like I'll see you all before then, but I appreciate your efforts. If there isn't anything else that we need to look at?
Your Honor, I've tried to follow up multiple times with plaintiff's counsel on whether Mr. Hernandez had been served so that we could get this accomplished. There's no obstructionary tactics here and she's not responding. So I'd just like maybe a representation to the court about whether he's been served. I'm just trying to find
I thought I heard her say that. I'm sorry, Ms. if I misheard. Ms. Haddon, do you have that update?
He has not been served with the petition. If Your Honor will remember back on our original hearing regarding their late designation of Hernandez as a responsible party, it was our understanding and based on our representation to the court that we would not formally serve him with the petition to include him as a full party until we actually got confirmation that he was the driver of that deposition that we were. It's not even one of the depositions that's before the court today. It's of that deposition of Hernandez, the supposed driver now. So per our understanding, he has not been served with the petition. We've asked defense counsel, since Mr. Larson has had a chance to speak with Mr. Hernandez, if they would accept service, since it appears to be the correct driver, and that was what I was told. No, they would not accept service and answer on his behalf. And so, to be consistent with what we had told the court, we're trying to move forward with subpoenaing his deposition because he has not appeared before the court as a full party. But if Mr. Larson would be agreeable today, I'm certainly agreeable to serving him instead with the full petition, as long as that will result in an answer being filed on his behalf. Oftentimes we're caught in this limbo land where we might serve a party with a petition who never formally requests an answer, and therefore now we're stuck in a limbo land that I can't speak to Mr. Hernandez, and it has no representation. So that was the workaround or the reason for this process being pursued this way.
Your Honor, I could address that real quick. So one, Hugo Hernandez has been named as a defendant. They have not served him with the petition. They continue to indicate they're going to serve him with a subpoena instead of the petition, which doesn't make any sense. He's not a non-party. It would be improper. And I've indicated that I cannot accept service because I don't have authority to. I cannot force that to happen. But I did indicate that we would answer as soon as they served him. And they've already served him at his correct address with the subpoena. They've already confirmed that's the right address. So there's no issue. Just serve him again with the petition. We'll answer, provide him for deposition, provide the corporate rep. It's not complicated. It shouldn't be complicated.
So I'm sorry, Ms. Haddon, why aren't we serving him with the petition?
Because until today, I had no assurance that that representation would be provided. He should be served with the petition and will, now that is clear, immediately. And that can help us streamline. I'm very grateful for that, movement in the case today.
Okay.
And I do disagree, but I don't think we need to beat a dead horse. I've indicated that several times, but yeah.
So we'll see you all on the May setting. Again, if you all need a hearing in the interim, let me know. Okay.
All right. Thank you.
Thank you, folks. Take care. Chewy, who's next?
Judge, bottom of page 2.
Okay.
It's cause number 2020 DCB 2473. Jose Alejandro Soto Leon et al. Versus CDC Transportation Inc. et al. Announcement of counsel, please.
Israel Guardiola for the plaintiff.
Marisa Ibarra Williams on behalf of defendants, Your Honor.
Good morning. And so we're here for a scheduling conference. Had we already discussed a trial date, a prospective trial date? Do you all?
Not yet, Your Honor. That's the one that we had just entered an appearance because we had just been informed of the case, and I hadn't received any materials yet. So I think if the court can just provide us with a trial date, we can get going and see where we can end up on this one.
Okay, let's do January 2023 as well. We'll send you a scheduling order. You'll return it. Please select a mediator. Have you all discussed a mediator?
No, we have not, Your Honor.
Mr. Guardiola, do you have any suggestions? Mr. Guardiola, are you there?
We've been using Mitch Mach or Carlos Villa, Your Honor. I don't know if Mr. Guardiola has any objection to either one, but
I don't see his phone number anymore, Your Honor.
His number's not there, yeah. We lost him. So let's see if we can get him back.
we've been having a Zoom kind of day today.
Yeah. I thought that was him with the 000s. Well, let's hang on just for a minute, Miss
No
Williams.
problem.
Let's see if we can get him back and get squared away. Chewy, let's call the next case.
Yes, Judge, top of page 3.
Go ahead.
It's cause number 2020 DCB 0749 Beacon Information Technology and Staffing Services Inc. versus Antonio A. Murguia et al. Announcement of counsel, please.
Robert Skipworth, Your Honor, on behalf of Beacon Information and Technologies and Staffing Services.
Good morning, Your Honor. Eric Darnell on behalf of the defendant in this matter, present and ready to proceed today on the status conference.
Okay, so we're set, yes, for the final status conference, although I see some entries, some things that were filed a couple of days ago. What are we doing? What's the update on this one, Mr. Skipworth?
Well, the update is the last time the court heard us was on my motion to compel discovery.
Mhm.
You signed the order on January
Yes,
28th.
ma'am. Is this the law office? Of
Trey,
Mr.
if you'll mute, please. Okay, go ahead. Sorry, Mr.
Judge, you signed the order
Mhm.
January 28th requiring responses to the discovery no later than 15 days
Mhm.
after the signing. That would have been, I believe, February 14th.
Mhm.
Last night at 8:15, Mr. Darnell e-filed some responses for two of my parties, but another two did not. I have received and reviewed those responses, and they are totally inadequate. They provide no information, are replete with objections, one of which is they're not going to respond until I respond to the request for disclosures. And we went over this last time, and I showed to the court we had served the responses for request disclosures on Mr. Darnell at least 5 times, and he still denies that he's received them. And then I get these responses to discovery that are nonsensical. And so in response to that, I have filed this morning a motion for sanctions against Mr. Darnell and his client for their failure to adequately respond to the discovery and for these nonsensical objections. I mean, we're playing games, and we're trying to move this case along, and I don't see that we're moving. He also filed a motion for an entry of judgment against my parties on the basis of his no evidence motion for summary judgment, which I still can't respond to because he still hasn't responded to the discovery. Now, the court has scheduled February 23rd a hearing on the no evidence motion for summary judgment. That means my response would be due today. Again, I don't have any discovery to help respond. And so we need a clear ruling that the court either continues that summary judgment hearing or dismisses the summary judgment or something. I mean, and then I need a hearing on my motion for sanctions.
So let me take these kind of in a different order. The motion for sanctions, I don't see it filed here, Mr. Skipworth. It's probably just processing through the clerks. As soon as it gets filed, immediately send that via email to request the hearing. Anticipate that hearing will be in 1 week.
Okay, I will do that.
I don't see, I see a motion hearing on March 23rd. I thought you had said February 23rd, and I don't know if that's for the summary judgment or not.
I think I may have misstated it.
Okay.
I thought it was February 23rd, which at the time I thought was kind of a short time for me to respond, but
right,
it is March 23rd.
I don't see any February 23rd setting. So Sandy, if you'll just double check me on that, if the request for hearing has been made, is that March 23rd date?
Your Honor, there's a March 23rd at 11 date, but it doesn't specify what kind of motions hearing, and I don't see a setting, but I'm looking for it now.
Did you receive a request on the February 14th motions to set those? I just see as entries on Odyssey a motion to extend and then motion for entry of no evidence summary judgment.
I had spoken to, I had communication with Ms. Carrillo from Mr. Skipworth, but they weren't accepted motions via e-filing yet, so they didn't reflect.
But Mr. Darnell's motions, we don't have requests for hearing on those, right?
I would have to double check with Mr. Dominguez, Judge, I'm sorry.
Okay. So I don't see them actually set, Mr. Skipworth. I see the setting for March 23rd. Right. I don't know, because we have had a little bit of transition with staff lately. I think that may predate. I don't see it correlating to the motions that were filed by Mr. Darnell on Monday. So, like I said, as soon as I have your filed motion for sanctions, like I said, and your request for hearing, anticipate we'll see you all next week on that. Other than that, I think I get where we are, but we don't have anything else to hear today.
Okay.
Mr. Darnell, we'll see you in 1 week.
Your Honor, we have the hearing on our no evidence motion for summary judgment to be set. And if I may respond, we filed our motion in November because they hadn't provided any competent, proper responses and never filed a response. So for Mr. Skipworth to represent that there's some response that he can make, it's too late. He's barred from responding in any way because it was already entered, and we have a motion for default on the no evidence motion for summary judgment, and we had we submitted it and timely submitted it. So yeah, we need to have it heard, and I can respond to the other issues.
Mr. Darnell, excuse me, your request for a hearing on that needs to be submitted via email. It is not set.
Okay.
All righty.
But we had reset the motion for no evidence summary judgment was set by the court. We filed it in November. It was set in December. It was reset by the court to January, and then my understanding it was raised at that time that it needed to be heard, and it was reset for today by the court. That's why we hadn't officially requested it. My understanding for sure that the first two times it was reset specifically by the court. And the time for Mr. Skipworth to answer was way back in December, so it's too late.
Mr. Darnell, that motion is not set for today. It is only a final status conference. So if you want that setting, request it via email along with any other motion that you want set, and we will get you your hearing.
We'll do that, Judge. Do you just an email, or do you need us to file a formal request for hearing?
The email with the attached motions.
What is it? On the March 23rd, what are we going? Excuse me, I'm sorry. On March 23rd, what are we going to hear then?
So I'm really not sure why that setting is there. As I mentioned, we've had some transition in terms of the coordinator spot on civil. So I don't see anything that is attached. There's no notation there. It just says motion hearing. So I'm not canceling it for now, but I don't see what it correlates to. Ms. Aguirre, if you see anything different, let me know.
Judge, you know what? So it was the time that I was out, but so I'm looking through my emails, and Mr. Darnell did request a hearing back end of November. But I don't see the formal setting going out for that March 23rd date. So I'm thinking, although there's no notice sent for that March 23rd date, that MSJ hearing was going to be for them.
Okay.
I can send formal notice for.
Okay. So we received the request from Mr. Darnell back in November. Okay, yes. Then we can use that date, the March 23rd date for that.
Okay.
Alrighty.
And again, I'll send formal notice, reference the specific motion.
Okay, and then the one for next week.
Yes, ma'am.
Alrighty.
All right.
Thank you, gentlemen. We have our dates. If you have anything else that you want heard, just let us know.
Will. Thank you, Your Honor.
Take care.
Thank you, Judge.
Mr. Skipworth. Who's next, Chewy?
Okay, Judge, page 3, 2533, middle of the page.
Okay, go ahead.
It's cause number 2021 DCB 2533, Richard A. Spoon versus LNJ Arredondo. Announcement of council, please.
Robert Skipworth, Your Honor, on behalf of the defendant Ricks, or actually plaintiff Ricks. They're involved in this case. What this involves is a driveway, and I believe Mr. Spoon is on one side of the driveway and my client Ricks is on the other side of the driveway. And we're both complaining about Mr. Arredondo's encroachments on the driveway. I understand that Mr. Spoon has settled with Mr. Arredondo, but but nobody settled with Ricks. So I think Mr. Dickey can probably address it better.
Your Honor, this is John Dickey. Mr. Zimprich and I are in the process of working out the settlement agreement. I think his client has reached his max, what he's willing to do. I'm trying to reach my client to see if we can finalize it, but his wife apparently was pregnant, so I couldn't get a hold. I haven't been able to get a hold of him the last couple of days. With regards to Mr. Skipworth's client, if the court will recall, I think about 30 days ago, we had a hearing. He wanted to consolidate the case that he had filed, the Rickses against Arredondo's, the 168th. But since this case had settled, I believe that motion was moot, and the court indicated it was moot, and I believe Mr. Skipworth agreed. So his case of the Rickses against Arredondo is in the 168th and not in this court.
That's correct.
This
That's
is
correct.
an entry of judgment hearing, and Mr. Zimprich can chime in if you'd like, but we're still working on that agreement. We're really close, but I just got to get my client to agree on some of the terms, but I believe it's settled.
And Mr. Skipworth, that's what my recollection is as well. So thank you. Mr. When you say we're really close, is 30 days really close? Or
Oh,
is it-
yeah, it shouldn't even take that long. I just got to get a hold of my client. If the court wants to set it 30 days, that should be more than enough time.
That's what we're doing. Mr. Zimprich, I haven't heard from you and I see your nice picture there, but are you there? John, he's there.
I can, if the court would just reset it, I can advise Mr. Zimprich it was reset.
I'm gonna go ahead and reset it for 30 days. Thank you so much.
I have several other hearings, Judge, so I will remain.
Oh, okay. All right. Sounds good. Judy, let's get moving.
Okay, Judge, I believe Mr. Guardiola is back on, so.
Okay. Let's take care of that.
Yes, ma'am. It's cause number 2020 DCV 2473. Jose Alejandro Soto Leon et al. Versus CDC Transportation Inc. et al. Announcement of council, please.
Israel Guardiola present for the plaintiff, Your Honor. Apologize for getting cut off.
Okay, and so we were discussing a trial date, but had not realized you had cut off, Mr. Guardiola. We're looking at January 27, 2023. I think we were talking about a mediator. Have you all discussed the mediator?
Yeah, that'll be fine, Your Honor.
Have you all discussed a mediator?
No, I don't believe we have, Your Honor.
Okay, I believe Ms. Williams suggested either Mr. Moss or Judge Villa. Any of those two agreeable?
Judge Villa will be fine, Your Honor.
Okay. If you all change your minds, indicate it on the scheduling order so we can make sure it's accurate. You'll get the scheduling order. Please return it to us before the 2 weeks and we won't have to see you until the next set. All righty. Thank you very much. Y'all are excused.
Thank you, Your Honor.
Thank you, Judge.
Who's next, Chewy?
Okay, Judge, 2913 on page 3.
Okay.
It's cause number 2021 DCV 2913. Jaime A. Montes versus Mimbela Contractors Inc. Announcement of council, please.
Morning, Your Honor. Gilbert Sanchez for the defendant.
Oh.
This is the one where Mr.
Yes, I just saw that. Have you been in touch with anyone, Mr. Sanchez? Do we have? No. Do we have any information on plaintiff? Sandy, do you see anything, or Mr. Sanchez, do you by any chance?
I don't, Judge, and no emails either.
Nothing, huh? Ay, Dios mío.
And I've called Mr. James's office and I get no answer.
Judge, in the past, and if I may, I've done it where I do a status or DWAP, whatever is your preference. I send it to the last known address on file for plaintiff to see how it is that they're going to, if at all, proceed. And then
Yeah, let's do that, because I think that was the idea behind the reset from January. I thought maybe we might know something more, but all right, just a status. We're not going to do it for DWAP. Okay, if we don't get anywhere next setting, let's do 30 days out. Then we will look at doing a DWAP, maybe 2 days. 2 weeks. Enough to get some information.
Mr. Sanchez, if I could trouble you terribly, if you have anything else reference the plaintiff, if maybe a telephone number or an email, if I could just trouble you for that via email when you get a chance.
I will email it to you. I have his personnel file, so I have his mailing address, and I have his last known phone number.
Perfect, all of that. Thank you.
Perfect. Thank you, Mr. Sanchez.
Thank you. Take care.
All right, who's next, Chewy?
Hey, Judge, bottom of page 3.
Okay, go ahead.
It's cause number 2020 DCV 2902. Diana Morales versus Benjamin Lopez. Announcement of council, please.
Good morning, Your Honor. Joe Spencer on behalf of Diana Morales.
Morning.
John Dickey on behalf of Benjamin Lopez.
Okay, so we're here for a final status conference. How are you all doing? We have a trial set on April 8th. We actually do have panels for that day.
Yeah.
So if you wanted a trial.
Yeah, we've completed, I think, all our discovery. I think Mr. Dickey will tell you that we're ready to go to trial. The only issue I have, Your Honor, is we also have, you and I have a murder case set on the same date. And I also have a conflict with a federal judge in Oklahoma on a federal case. The issue with that case, Judge, is that we were specially said it's a 4-week trial. It was specially said to start February 22nd. When we were there last week at the judges conference, the judge told us that she's going to assign a visiting judge, that she's not going to hear it, and that we're going to get another date, but it will be within a week or two. That was last week. To this day, we don't have the visiting judge yet. I don't have a trial date. I just want to let the court know there's a potential for a conflict, but I'd like to keep the trial date. Our trial, I think, will be really quick. So hope, but then I don't know what the issue is going to be with our other criminal case, right?
Okay, Mr. Dickey, do you have anything to add?
Well, I do not have anything set on the 8th. I have, earlier in that week, I have 4 trials set. But they should be done by then, but I don't have anything the week of the 11th. So if the court's available, I'm available.
So let's do a couple of things.
But if there's a murder trial, then I would rather move it than wait till the last minute.
Yeah. It's very tricky, and I'm really not sure anymore what is the best way to handle all of these situations, knowing that we're limited panels, blah, blah, blah. This is what I'm going to do, a couple of things. Because I know we have 4 panels, I'm going to add April 7th. We're going to keep the date. I think it's highly unlikely, but we're going to keep it because God knows so many things can happen. And maybe you would be my last case that is ready to go. If that's what you're telling me, I don't want to push it. And then everything else that could have gone doesn't go, and I could have given you all that date. So we're going to leave that date, but we're going to add a backup of January 14th. I'm sorry, not January, July 14th and 15th. It's not too far off.
Okay.
And at least that way I have you all in the queue as a case that's ready. Not everybody's totally ready. Sometimes we're pushing people.
I agree with Mr. Spencer. We're ready, and I don't believe this is going to take very long. If we pick the jury on a Friday, we can do all the evidence, I think, on Monday.
Okay. Well, see, on that April date, the reason I'm saying adding April 7th, Mr. Dickey, is because I actually have 2 panels coming in on the 7th as well. So if you think it can be done that quickly, shoot.
Well, my only concern is if I'm in trial earlier that week, I don't know if I'm going to start on Monday or Tuesday.
I see.
So if you try to start me on Thursday, I may go from, I'm getting too old to try 2 cases in a week.
Okay, we'll leave it at the 8th. Just, Chewy, you're gonna have to remind me, or somebody's gonna have to remind me, like if we cancel the 7th, that I know I still have this one ready to go on the 8th.
Yeah, and Judge, just, also I am supposedly we're set on the 5th of April in the 168th on another civil case, but I don't think it's going to go. So I want to keep our date because I think ours will be quick. So I just want to put that on the court's radar and not spring it at the last minute in case something happens.
Okay.
I'm hoping to get our case done, Judge, because it is going to be quick.
I got you. Thank you, guys. We'll get you a backup date.
Is there a docket? Do you have a docket call on the Wednesday before that, or?
Yeah, there is, John, and I'll reach out to you and give you that, let you know.
Okay, because I thought at least we'd know by Wednesday.
Yeah.
Okay.
All right. Yeah, we should have that setting. All righty. Let's see how everything shakes out. Thank you guys so much.
Thank you, Your Honor. May be excused.
Yes, sir. Thank you.
Thank you.
Who's next, Chewy?
Judge, the second one on page 3.
Okay. All right.
It's cause number 2021 DCB 0749. Jorge Rivera versus Arturo Garcia Medina. Announcement of counsel, please.
Good morning, Your Honor. Victor Serrano on behalf of the plaintiff.
Good morning.
Good morning, Your Honor. Chris Estrada on behalf of the defendant.
All righty. This is another one of our April 1st trials. How are we doing? Final status conference.
Well, Judge, Mr. Estrada and I have spoken before, and I'm hoping to get in touch with my client within the next couple of weeks, so maybe it might result in a non-suit. I will advise my client to do that based on information that Ms. Estrada and Mr. Darnell have provided to me.
Okay, we'll see you on March 2nd. We have a setting already. Are you all good with that?
Yes, Judge, I think we can do that.
If you know you're at a non-suit already, like before that date, feel free to send it over.
I'll do that, Judge. I will inform Mr. Estrada and Mr. Darnell also.
Thank you, guys.
Judge.
Take care.
Thank you, Judge.
Have an excuse, Judge.
Yes, sir. Thank you.
Thank
Who's
you.
next, Chewy?
Hey, Judge, top of page 4. It's cause number 2019 DCB 4041. Patricia Medrano et al. Versus Jessica Valdez. Announcement of counsel, please.
Victoria Terrazas on behalf of Mr. Carlos Quinones, representing Patricia Medrano, the plaintiffs.
John Dickey on behalf of the defendant.
Good morning. So motion for continuance. I felt like this was already taken care of, but we have a motion for continuance, I believe, from Mr. Rosas. Is that right?
Yes, Your Honor. Sorry.
It was unopposed, Mr. Dickey?
It is unopposed, Judge, and you're right. I believe at the last hearing, Mr. Rosas indicated that she was due on or about that time, and I did not oppose the continuance. So I agree with the court. I thought you had already granted that.
I thought I had too. And so let me ask this, maybe my only question was timetable. I don't know. Had we discussed that last time? I'm thinking, oh, well, I don't want to push it. I don't know. I'm thinking July, but if you want something later, I'm happy to do that.
I'll leave it to Mr. Rosas, whatever she feels that she's able
that's
to go
pretty
back.
much for you, Mr. Rosas. When are you able to try a case?
Judge, I think July will be fine. Also, my boss will be able to assist. I mean, he's the main attorney. But if we can have something later, that's even better, yeah.
Okay. Sandy, what is our regular, I hate to put the regular trial stuff. This is otherwise ready to go. Is that right? Okay.
Yes,
so then let's do that July 14th and 15th, and we'll see what happens.
Okay. Judge.
Okay. All righty. Thank you very much. Thank you, Mr. Dickey.
Thank you, Judge. I have one more, so I'll hang on.
Okay. Chewy. Yes, you may be excused. Good luck to you, ma'am.
Thank you, Judge.
All right. Who's next?
Just to see if anyone is here on behalf of the plaintiff for Daniel Avila.
Your Honor, I'm John Dickey on behalf of the defendant. The case is settled. But I will advise the court that it's settled, but we've agreed to make, I believe it's 8 monthly payments, and then all the amounts will be due. So if the court would allow to just leave the case open so we could pay it off, so we don't have to, I figured it probably wouldn't get a trial setting before the amounts were due anyway. But we've settled it. My client just has to make 8 monthly payments, and I believe the first one has already been made.
Okay. So I am going to, Sandy, we're going to cancel March, April settings. We're going to do are we on payment 1, Mr. Dickey?
Yes, Judge. And we had, I believe we had already have an agreed judgment in the event my client doesn't pay.
Yes,
so the court's not going to have to hear this.
Yes. So we're going to go all the way out to, we're going to go to September 21st status. That's
Fine,
just to check in. And if we need to do something else, we'll do something else.
That's fine. Thank you, Judge.
Thank you. Is that all
Thank
your
you.
cases?
I'm done. Thank you, Judge. Have a
Adios.
nice day.
Thank you very much. You too. Who's
Bye.
next, Judy?
Hey, Judge, on page 40105, Mr. Duran is here. I'm just seeing if anyone is here for the defense.
Yes, Daniel Martinez here for the defendant.
Give me 1 second, sir. Okay, Judge, this is cause number 2019 DCV 0105. Maria Socorro Alvarado et al. Versus Rafael G. Gonzalez. Announcement of counsel, please.
Mr. Duran, you're muted.
Sorry, David Duran for the defendant.
Daniel Martinez for the defendant.
Okay, we're set for a status hearing today. We do have a good jury trial date set in July. How are we doing on this one?
Judge, they have filed a notice of another expert. I think it's expert number 5. I may depose that last one, but you set the case for trial on July the 14th, and I'm in trial in another case that's an older case that in all likelihood will go.
Okay. So what we're going to do with that is we're going to give you a backup date to that date. In the event your other case falls through and you're available, I want to hold on to that date, Mr. Duran, because it's actually a date where I have panels. I know when I reset this last time, it was with that idea that we actually have jury panels ready for those trial settings. So we'll give them a backup date of November 4th. Well, Sandy, I don't want to go that far down. Sorry. If we're talking July, let's do September 21st. I'm sorry, September 21st would be the docket call. The 23rd would be the trial date. Please, Monday.
All I wanted to say there was, I'm not familiar with the file. The handling attorney recently left the firm. We're bringing in a new associate into El Paso to our satellite office there to pick up this file. But and David, I'm happy to talk about it with you. We don't typically hire 5 experts, man. That sounds like a way out of line from the norm. But I'll check in with you. Perhaps we can talk about it afterwards.
It's a continuous dispute whether my client's operated back was caused by this accident that occurred. And so there's a causation issue, and there have been multiple experts that have been named. The last one, Judge, I don't even recall who it is, but really haven't had an opportunity to investigate or to set some type of deposition notice in reference to that last expert.
Yeah, I'm not trying to dispute anything there, man. I'm just saying that's out of the ordinary for us, and I'll give you a call after the hearing.
So there's a couple of things. We're not coming back until June. I don't have you set for anything until June. So a couple of things, Mr. Martinez, I know you might not end up being still the point of contact, but I know we still have Ms. Del Valle on here. So whoever becomes the point of contact, we need to update that for our purposes, sending out notice, things of that nature.
Yes, Your Honor. I'll make sure
And then
notice is filed.
Because we don't have you back. I mean, I'm not trying to bring you all back every, month or whatever, but if you all are going to have something, do you want to come back in 30 days or do you want to just stick with the GP?
I don't think we have anything right now or the need to come back.
If you need a hearing on anything, both you, Mr. Duran, you, Mr. Martinez, please notify us via email with the attached pleading and we will set it for a hearing. Okay?
All right, that's fair enough, Judge.
Thank you very much.
Thank you, Your Honor.
Take care.
Thank you.
Who's next, Julie?
Okay, Judge, top of page 5.
Okay.
It's cause number 2021 DCV 3028. Rosa Maria Salcedo et al. Versus Fifth Floor Freight LLC et al. Announcement of council, please.
This is Matt Greenberg for the Alonso family.
Norman Snyder for Fifth Floor Freight LLC.
Stuart Forbes for the interveners.
Nick Pena, attorney for Claudia Guzman.
Sean Page for defendant Detmar. Your Honor, we're ready, subject to maybe a bathroom break. I've been on here since 10.
That's a great idea. We're taking 5 minutes. That's it. 5 minutes. We'll take a break off of YouTube. Right back. Okay, wonderful.